OE-0149, Eric B. Mack versus Thomas M. Quinn III in his official capacity as Bristol County District Attorney.
Okay, Attorney Stern.
Good morning, Your Honor. Shoshana Stern for Bristol District Attorney Thomas M. Quinn III in his official capacity. This case is here on the Commonwealth's motion to dismiss the plaintiff's petition for failure to state a claim on which relief can be granted. The parties disagree about whether the plaintiff suggests that the appropriate standard is a Rule 12b6 standard. The Commonwealth takes the position that this court can consider all the information before, but regardless, we would maintain the result is the same. The core of the
So what is the legal standard in your view?
I mean, the legal standard is that this court, a majority of this court can remove a district attorney for sufficient cause when the public good requires. So this court could.
But how do we, it's here on a motion to dismiss, so.
Yes.
Normally we look at, we apply our 12b6 rules.
Yes, I mean.
But here.
Sorry?
Here we have the Rule 30, Article 30 overlay.
Yes.
I get that, so.
Yes, so I would.
So what's our legal standard?
So
other than what the statute says?
Yes. I don't know that this court has set a precise legal standard. One thing that has come up, there was in an 1858 case, Bullock, was that they dismissed the petition for failure to have sworn affidavits of allegations, which this also does. But in terms of the facts that the court can consider, there is not a specific rule that has been set out. There are examples of cases that have been heard. I looked through Boston Globe records, and there are instances where petitions were dismissed without legal record, but that's not obviously in the record of the court. And you don't always, even the ones that are heard, we don't have all the information.
So are you saying you don't have a case where we've allowed a motion to dismiss other than the Bullock case?
There's 4 cases that got heard. There's a case where a single justice dismissed a petition for lack of standing on the single justice docket where it concerned a clerk. And the original entry records don't go back before the 90s, so there's a lack of other records about how other cases might have been disposed. The decisions that we have, which are from 1921, 1922, and I think in the 50s or 60s, are the only case law that happened to address sort of fully what happened in cases where it was not dismissed. And so we don't know beyond, there's evidence that they have been dismissed in the past, but there's not a clear statement of here's how we know when we hear it or we don't, which again, with the Article 30 overlay, is a very interesting question. And so there's the question of what showing needs to be made, and also the question of what substantive showing needs to be made and what mechanism the showing is made by. I would suggest as a general matter, 211.4 is written as a statute for extreme circumstances. 12b6 is a minimum standard for routine pleadings. I think certainly this court should not constrain itself to hear every claim brought under the statute that would meet the requirements of 12b6, though we would argue that the present petition does not, and that is a minimum standard.
So the 2 cases that have gone forward, right, the 2 involving the DA, one, the DA was sort of misusing a trust, right? He profits from he sells land and he profits the money, right?
Yeah,
so,
he's the trustee and he
right.
essentially.
And the second one, remind me the facts.
2, there's Tufts and Pelletier. They're both in 1920, 1921 era. The Middlesex DA and the Suffolk DA have somewhat different conduct, but they're essentially both selling their office for advantage. They're charging people with crimes and then taking money from them not to be prosecuted. And in Pelletier, at least, there was the issue that the AG charged in the alternative, like, once you've done this, either you have probable cause.
And they were personal to the DA as opposed to here, which is more the DA and his supervisory
Yes, Your Honor.
responsibility, right?
So certainly in terms of what has been decided, those were very extreme fact patterns.
Both of them involved taking money, right? Or
Yes, I mean, not every, some of them involved influence, that the money went to a friend of the district
okay.
attorney,
Right.
but that the DA was essentially using the office of the DA as a mechanism for public corruption in a fairly blatant way. In terms of how...
And so when you said there are others out there, so the case law that we've got are the ones that survived motions dismissed, but you think there are a bunch where the dismissals are allowed, or just the single justice one is the only one you?
That's the only one I have a court record of. When I again, outside the court record, there was a reference in the paper, there was an earlier 211-4 petition in Pelletier that was dismissed, that didn't allege as much, that was by private citizens, ultimately it did. And the first Flynn petition got dismissed as too vague, and then the AG brought it again with more information. And again, that's just, happening to see it. But I don't know, you wouldn't see that on Lexis.
In both of those other cases, there's AG involvement. I understand.
All four.
Can I shift you a little bit to the standing issue? So our standing, we've allowed basically a filing, but is this the first time in history we've allowed anyone to do anything beyond make a filing if they're not the attorney generals?
So there in Mass Bar Association versus Cronin, it's the Bar Association. But
then
this is the first,
we basically say,
and that's a clerk.
But we just say basically to the MBA, okay, you filed, but you're done, right?
Yeah,
Right.
yeah, and so essentially they have all been brought by the Attorney General under extensive proceedings where clearly it doesn't detail what happened before, but clearly there was a lot of before that went into it. And in at least one reference, there is, in Pelletier, there was the subsequent additional information from the Attorney General after the Pelletier went to the public and said, anyone who says I'm going to resign, fight them and I'll null-pros your conviction. And the AG added to the 211-4 petition, but specifically submitted an affidavit saying, here's my personal knowledge of this.
But why shouldn't we do that here? Say, okay, the issue's been brought before us, and we'll toss it to the AG,
Toss it to what?
to the Attorney General.
Oh, I mean, I don't know that that's ever happened before either. I don't think anything would necessarily prevent you. I mean, the Attorney General could do what they wanted. This has been pending for over 2 years, I believe. So the statute doesn't provide for that, but this court can set its own procedure if you thought that was appropriate. I think that just the important thing is that the court not sit on initial review on claims that the DA is making the wrong decisions on matters of its potential competency that causes a lot of potential problems, both for Article 30, for chilling effect, for general practical, It is the nature of the office of the district attorney that there will always be people who, for whatever reason, however rightly or wrongly, think that the DA's decisions are so wrong-headed that they can only be explained by corrupt motives, even if they don't have any evidence of those. And, I mean, this court can't be...
Is there also one thing I'm trying to understand, is there an alternative remedy for every allegation here? So the petitioner's brother's case, that's a Section 1983 claim can be brought at least against the police. Maybe not, I don't know if they can be brought against the district attorney's office, but they can be brought against the police, right?
I know in Louise Barreto, there is a federal case against that the family brought against the Fall River Police, which I believe is referenced in plaintiff's motion for discovery. He says, well, that's already being investigated, so I'm not asking for discovery on that now. They moved to depose the district attorney, which was quashed by a federal judge on Friday on the grounds that they were looking for deliberative privilege information, and they hadn't tied the DA to their allegations of conspiracy to the Fall River Police. So that's actively ongoing. The plaintiff also attached an article showing that the family in that case was arguing at least that the DOJ, arguing in the newspaper that the DOJ should take that case. They evidently have not. They did prosecute the same officer on different conduct that we actively worked with them on because I don't know that that's specifically in the record, but essentially he got convicted of filing false reports and
Right, so there are a couple of claims against police officers that are subject to 1983 actions. There's a couple of claims, there's the Board of Bar Overseers issue related to the conduct of the first assistant.
Yes, Your Honor.
There are ongoing proceedings on a lot of these things that may make our role here unclear, right, or duplicative.
I mean, I know he takes the position that a number of them are clear, though we take the position they're not clear. I mean, so.
But he's going to drop out of the case,
Yes.
right? there's no authority for him to continue in this.
This court would have to appoint somebody to take on, I think, that role in the
Right.
case if it were not the Attorney General, if it survived the sort of basic
And is the
review.
Attorney General the only choice that wouldn't involve a separation of powers issue? Because the Attorney General is also a prosecutorial entity,
Yeah.
so I take it, well, I guess there's a different type of separation of powers issue, but it's not the same
Yeah.
one as the judiciary interfering with the prosecution.
And the Attorney General has not chosen to prosecute either of the officers, any of this conduct either, which they could do, which suggests that they may not see a basis for.
Have there been referrals to the AG's office already in this case, in the record? Not by you, obviously, but.
Yeah, I'm not specifically aware. I know that the issue has been discussed a lot in various news, but I don't know. But, yes,
In
so,
your view, who can bring one of these claims other than the Attorney General, if anyone?
I mean, I think as a matter of law, anyone can bring it, but they are supposed, ultimately, it then becomes a matter between this court and the district attorney, and that there does need to be some mechanism, just as a purely practical matter, to ensure that every grievance against a district attorney does not have to go through formal processing by this court.
Right, so I stand corrected that it's not that only the AG can bring it, but once a person files the initial pleading here, in your view, is there any entity or person other than the Attorney General's office that can then carry the ball beyond that?
I mean, I'm not in a position to argue that there's a preclusion, but it does seem difficult to sort of answer who that would be. If there was, I mean, again, it's an unusual situation. The statute has not been used very often, and a lot of it was.
So do you have a proposal as to what the mechanism would be here? Were it to go over to were we to agree with you and think that the Attorney General is the proper person to carry it forward? What would be the mechanism to achieve that?
I don't know. I mean, I don't think that, for the same reasons, I don't think this office, or not this office, this court could require the Attorney General to bring a 211-4 petition, obviously, if the Attorney General did not think it was warranted. So in that sense, it would be.
Maybe a dismissal without prejudice?
Yeah.
For the Attorney General to then decide?
Well, I mean, didn't we decide this issue in the NBA case where the NBA brought the case and then we referred it to the AG, and the AG in that case decided to step in?
I don't remember actually who took over in Cronin. It was a clerk, so this court had much more power to decide issues that they do not for a member of the executive branch.
But we decided in that case that the AG was not the only entity
Oh, yes.
that could bring the case.
But that the person who brings the case then falls out of the case.
Well, that's just what happened. We didn't decide that that was necessary, did we?
Well, I mean, it specifically says it doesn't matter who brought this because the person falls out of the case, they are only a witness. So that anyone can bring it, but that ultimately then it just becomes about the district.
Well, I thought the case actually says it doesn't matter who brought it because once the alleged misconduct is brought to our attention, we can look into it consistent with our responsibilities for the administration of justice. It did not say that the NBA had to drop out. It just happened to happen that way.
I mean, I read it differently, but obviously, the case says what it says. But again, I think that and this is an instant, I mean, so the statute does not itself provide any sort of firm guidelines on these things, but it is important to sort of have a framework whereby this court does not do an initial review of every grievance claim against a district attorney for whether it was a proper exercise of Article 30 role, particularly where I think I would argue even under Rule 12b-6, the facts alleged, the accusations of improper motive and of corrupt conspiracy are all matters of opinion as alleged even under the deferential 12b-6 standards, that he does not allege facts beyond disagreeing with the DA's credibility determinations and discretionary decisions. And I know he has a pending motion for appointment of special master in discovery, and we would argue that should be resolved by dismissal of the petition, but I note that he specifically says that he wants discovery expedited to use in the next election, saying on balance any hardship to respondent is outweighed by the hardship imposed on the public by not having the requisite information to make an informed decision prior to the next election. This is not a role the court can should take on not an appropriate use of the statute. It's not a vehicle for this court to oversee opposition research on a issue of who should represent the people of a particular county. It's its own matter for extraordinary important circumstances, but it needs to be limited closely to those circumstances to survive constitutional review. Thank you, Your Honors.
Okay, thank you. Okay, Mr. Mack.
Petitioner Eric Mack. Well, a lot of your questions allude to the same thing here. What do you do, right? And the answer to that is you can pretty much do whatever you want. That's literally the answer, because the case law here doesn't really address it. The first issue in terms of standing, I think, is pretty clear. The Massachusetts Bar Association says I have standing to bring the claim. The second step in that is what happens after that, right? That is why I made the request for a special master to do the discovery in this case. I don't think there's anything that I've seen that limits discovery to only the Attorney General's office. I mean, you could read some of the cases that say that, but I don't believe any of them actually come out and say that to the effect.
But don't some of the other cases besides Cronin say that you drop out? Once you file, you're done, right?
Yeah. Yes, they do. And I sort of analogize this to the EEOC and Waffle House case. The Supreme Court is not cited in my briefs, but it's the same concept in terms of the plaintiff dropping out of the case and becoming a witness for it. In certain sense, they can provide evidence. They can sort of inform the court where to go and what information to get. However, they do not make final decisions and things like that. So I believe that there's a role to be played, but there's somebody else driving the bus, I guess, essentially in that sort of situation.
Why are you asking for a special master as opposed to asking to have it referred to the Attorney General?
I believe a special master is more of an impartial, outside the government individual or entity in the situation. The Attorney General has the authority to bring these claims on their own, I would say, and continue with them on their own. A special master, I would say, is, more of an independent arbiter of what takes place, and would be appointed by the court in this case.
But doesn't that create a greater separation of powers problem? Because the special master would be master for the judiciary. At least the AG's office is separate from the judiciary and a prosecutorial entity as opposed to a judicial entity, right?
I sort of see those as two distinct issues here. The prosecutorial aspect of it is bringing criminal charges and prosecuting somebody in that manner, whereas the removal proceedings is a civil proceeding where it does not involve bringing criminal charges, which does not have to be the Attorney General. When you read the case, the Shepard case, for example, I believe, the court was basically like, our hands are tied. We cannot impose any criminal charges, even though there was probable cause to move forward.
But Attorney Mack, so the issue we have now that's before us, so you bring the claim and you drop out
Yes.
if it goes forward, but it's the if it goes forward part that we're litigating today, correct? The
You
dismissal.
mean the 12B6?
Yeah. We'll see.
I consider it 12B6.
Yeah, well, the motion to dismiss, we're going to litigate exactly.
I caution the court at this stage because we're at the 12B. I don't know what you want to call it. We're at the
Motion to
initial pleading
dismiss.
stage, right?
Right.
And therefore, the whole record is framed by the records that I have basically from the government. I haven't had the opportunity to test any of their statements, any of the records, or anything like that. So it's at a sort of a disadvantage to assume, I guess, everything they said.
That's every motion to dismiss, right? It's whatever you've brought to the court as far as your complaint.
Yeah, and
We
I
have to judge whether or not what you say and whether it's in the light most favorable. We assume what you say is true. We have to assess whether or not the case should go forward.
Yeah, and I don't know whether the court is adopting that standard, quite frankly, assuming everything that I say is true. And I guess if you do assume everything that I say is true, the second layer is there a claim stated, right?
Right.
That's the essential claim here. And I guess the biggest issue here is sort of the conflict of interest. I guess you probably all briefed that between the district attorney and the son and the sister working there. I think that those overcome the 12B6 standard. I think that the issue with, this is a public good issue, right? So the substantive law here is less than clear about whether I can overcome the 12B6, because the 12B6 is, have you stated a claim under the law? the law here substantively is the public good, right? So I think that that's a hard conceptually to say whether or not it's good or bad. I think that's sort of before the court to make that type of decision.
Well, Attorney Mack, you also have this issue where, you cobble together everything into one.
Yes.
And if you separate them out, the real difficulty is the public good in perhaps not making decisions that you wish the district attorney had made otherwise. And so in aggregating all of that and saying that equals that this district attorney should be removed, are we supposed to look at all of the individual component parts of this and say, hey, he gets to choose who he wants as his first assistant, whether you like that or not, and whether it involves actions that predated her working for him or not, or all of the other individual component parts?
Yes and no, and I hate to answer a question like that. But yes, the totality of the circumstances, I believe, matter, right? And I believe that, don't quote me, I believe the Tufts case says the totality of the circumstances.
But the Tufts case, though, back to Justice Kafker's question or point, these were all things that folks were doing themselves, right? This isn't that case.
I would disagree that some of this is what he did this himself. I mean, I think the conflict of interest is himself. And I also think there's a layer to that I don't know, right? There's a layer to I don't know what he's done, him or herself, because there's no discovery that's taken place. And I'd actually argue the retention of the ADA is something that he did himself. So I don't know if I necessarily agree that none of this is something that he did himself.
That's the only one, though, that I saw, based on the allegations in the pleading, is the hiring of the ADA, correct?
There were two, Your Honor, I think.
What's the other?
Well, the other one was the conflict of interest, I would argue.
What did he do himself?
Well, he did not disclose the conflict with the individual working there, or his son being the individual investigated his best friend, and then he cleared the officer. So I argue that he did that himself, and I don't think I would not.
The officer's not the shooter, right? The officer is the partner of the shooter, right?
We have some disagreement there. I don't know if you in terms of whether or not that individual fired their gun. There is a disagreement as far as I know, in the record, because there was a witness who said that there was more than 2 shots fired, and only 2 shots were fired from the shooter's gun, and the other individual's gun was never tested. So there's sort of a difference of opinion, I would say, in that assertion.
How do we prevent this type of action from becoming a fishing expedition? You're saying you don't know what you don't know, and that is a truism, but it doesn't allow us to convert this cause of action, which is really a limited one, into allowing you to know, right? You could make a public records request. I don't know what else you could do, but.
Well, one answer to your last question, the public, I subsequently served the motion to do discovery, and then I subsequently filed a motion, sent the public records request to see if anything was done sort of in response to that under the Graham, Hampden County, and sort of the investigatory. And I was sent back a request to pay $36,000 to get the response to that. So, there's some limitations on what information that they were giving me. But to your first point about it not being sort of a fishing expedition, I think there's about 1,000 pages or so of information within there. So I think we're past the sort of initial normal pleading standard, right, on something like this. And there can arguably some level of an intermediate step, which I argue would be a special master or a single justice to look into this to see whether there's sufficient cause to be shown.
But the statute is extraordinary, and it's been applied in extraordinary means. I know you think your case is extraordinary, but the overlay we have is Article 30. So you're asking us to remove the people's elected representative and to say that, and essentially violate the separation of powers for extraordinary means, since it's essentially an impeachment.
Two answers to that. One is Article 30, it was an amendment to the Constitution, which gave this court, I believe, the authority to look at that. So I don't think you're stepping on the legislature's feet about doing that. And the second issue is,
Well, we did it in Tufts and Pelletier for very extraordinary cases.
The second level of that sort of
Can I
analysis.
ask you to stick to the first level, though?
What's the first? I'm sorry.
The first level was that, you said that we were given this power, and so it doesn't violate Article 30.
Yep.
But if we use the power in cases that are not extreme,
Yes.
then do we have the Article 30 problem?
Well, yeah, obviously, extreme is on a spectrum, right? In terms of what this court deems as extreme and its sort of analysis. Somebody asked a question about impeachment, sort of phrase. I believe it might have been you. When you look at, I would argue that impeachment is a lower bar than would need to be met here, right? I mean, the safeguards in place here are that it comes to this court.
Well, the safeguard is the next election.
In all elected officials, the safeguards at the next election, but some of them can be recalled, right? Some of them can be impeached. So there are different avenues. Having one single avenue, I would argue, is not the only way. There's a specific avenue that is given by the legislature to this court. So I don't think that necessarily precludes it. Is there any other question?
You were going to have another, did you answer both of the ways?
Your first question, I'm sorry, I got sidetracked. I think it was like, how do we prevent other people from coming before the court? I would argue that, first of all, people coming before the court, I don't think is a problem per se. I think the public should have the opportunity to present cases to the court. Whether or not they meet the standard, that's, comes before the court all the time in terms of precluding claims or going forward, or whether enough evidence has been shown. So I don't think that's problematic in terms of the public having the ability to do it. If there were, a master appointed to determine whether or not the sufficient cause needs to be shown, I think that there's some level of discovery that would need to be done in order for the matter to probably get up to the court for a final determination.
I guess that's the problem, though, because we don't really have any gating requirements for 211-4 that we can point to our case law to say this is what we're supposed to do. You want a 12b6 component to it. There's a lot that's in your pleadings that's based on information and belief, and could be an argument that it doesn't satisfy the pleading standard. But then to go and say, well, we don't know, but if we were to follow your logic, Rule 26 says there is a metric to when you get the discovery, and it's not, I don't know until I know.
I believe it's relevance to the pleadings, Rule 26, right?
It's likely to result in the discovery of admissible evidence. So there's got to be some baseline. It's not just I don't know until I go about the discovery process.
Yeah, I guess.
Hold on, let me finish.
Sorry.
So if every time somebody is dissatisfied with a district attorney's decision not to do something or to retain somebody that you perhaps don't like, we're going to turn the SJC into a screening device?
Well, I would not say the SJC per se, but I do think a sort of an intermediate step after the pleadings to see if there is if there's enough to actually make a decision here about whether it is the public goods should be satisfied. And whether or not the 12b6 standard applies, I don't know. There's language in Pelletier that appears to suggest that the rules of civil procedure apply, which I would argue, 12b6 is one, but there's no express statement about, 12b6 applying. And regarding some of your questions, the substantive law here is not clear. Public good, right? It's just so broad that what is relevant to that is almost whatever the court decides is relevant to the public good. So it's hard to really analyze and answer that question substantively at this point in time.
Did you take your concerns to the Attorney General's office before filing your pleading here?
I have not. I'm getting to read that. I might have that. It might be my suggestion.
No, I'm just wondering because I can imagine that if you had and the AG had declined to pursue it, it might affect at least my view of whether, where we would go from here.
I respect.
But you haven't.
I have not, but I
gone there.
respectfully disagree with that analysis, in my personal opinion. I don't think it's limited by the AG's role in this. I know that a lot of cases have gone to the AG, but I don't see anything that requires that. So.
Well, there would need to be someone who could make litigation decisions, because you will drop out. So it's hard to, a special master doesn't normally make litigation decisions. So it's really hard to, when you survey the universe, both for Article 30 reasons and other ones, it's hard to imagine how we don't end up with the Attorney General.
It says that, I don't say I must drop out. I read it as it has happened and can happen, but not obligatory. So, that is an issue that would probably be decided.
But I thought you said you were willing to step out and be the witness.
I'm willing to. Yeah. I'm definitely willing to, if you want to appoint somebody else to do it, or another entity. But at the same time, I don't know if that's required.